Today, we're going to talk about the differences and the similarities between Chapter 7, Chapter 11, and Chapter 13 bankruptcy. At their core, all of these chapters of bankruptcy are really doing the same thing. You are filing a written petition with the bankruptcy court, which gives you protection from debt. Now, these three chapters are going to go about this protection in very different ways. So it's important to understand how these chapters are different and similar to each other. A Chapter 7 bankruptcy is what we call a liquidation bankruptcy. The bankruptcy trustee will look to see, is there any property that can be sold, paid to the creditors so the creditors can get pennies on the dollar, and then the person filing bankruptcy isn't actually going to be making payments on those debts. Most everyday people are choosing Chapter 7 so that they're not making payments. They're just showing that they're broke, showing that they probably don't have anything to liquidate, and then getting out of debt. A Chapter 13 bankruptcy is a payment plan bankruptcy. There isn't going to be a liquidation going on. This is just monthly payments paying towards the debt. Not necessarily paying all of it, but it's a payment plan bankruptcy. This is chosen often by people who are higher income or people trying to stop a foreclosure. That's usually our Chapter 13s, and occasionally somebody who's recently filed a Chapter 7 and can't file another one because they're time barred. And then a Chapter 11 has similarities to both. It's frequently used by the largest of corporations, but can actually also be used by individuals. So let's talk about some of the ways that these chapters are different and similar. Let's start with a trustee. A trustee is somebody appointed by the U.S. Trustee Program through the Department of Justice. And this is a neutral individual who's going to work on the case. In Chapter 7, there's a trustee. There's usually a panel of them. One of these gets randomly appointed, and this is the person in charge of that liquidation. Is there going to be one? What are they going to sell? That's the Chapter 7 trustee's job. Now, over in Chapter 13, we also have a trustee called the Chapter 13 trustee. Unless you live in like Chicago, there's usually just one Chapter 13 trustee. And that is an individual appointed by the government to oversee all the payments. Trustee's office is like a large clearinghouse for money because in the Chapter 13, you submit one monthly payment to this trustee. He's not liquidating, he's collecting payments. And then the trustee is going to cut checks every month to all the different creditors. Chapter 11 usually doesn't have a trustee. In Chapter 11, it's a lot more customizable. Also means a lot more expensive. And there usually is a committee of unsecured creditors. All the people that you owe the most money to, that have the most at stake, get together as a group and they figure out what makes more sense here. Do we need payments? Do we need restructuring of the debt? Or do we just need to liquidate all of your things? So that's a more flexible route. Sometimes the Department of Justice will appoint a trustee, but not always. Chapter 11, this is less than 5% of the bankruptcies in Oklahoma, and less than 1% are an individual filing a Chapter 11. Really, the ones that are filing a Chapter 11, think of an oil company, think of a construction company, a pipeline company, maybe a marina that's failed. This is very, very infrequently used for a Chapter 11 for an individual because it's just so expensive. And for the most part, you can achieve those goals in Chapter 7 or Chapter 13. Now, one thing that Chapter 13 has that none of the other chapters do is a debt limit. There's actually a maximum of how much money you can be paying through a Chapter 13. And if your debt exceeds certain amounts, you can't file a Chapter 13. Is there a debt minimum? Well, there really isn't for any of these chapters. For all these chapters, the minimum I say is when the debt becomes too much and you can't deal with it on your own, that's when it's time to file bankruptcy. So Chapter 13's got that maximum, the other two don't. In Chapter 7 bankruptcy, there are income limits. If you earn too much money, it gets hard to file a Chapter 7. There's some exceptions, there's some ways in, but for the most part, Chapter 7 has an income limit where Chapter 13 just has the debt limit. What then do you do if you're too high income and too high debt? Well, that's the really rare individual that chooses a Chapter 11 and probably pays their attorneys a lot of money. Who can file these different chapters of bankruptcy? An individual can file a Chapter 7, an 11, or a 13, but a business can't. By law, only a person, an individual, can file a Chapter 13 bankruptcy. So businesses can file 7s, businesses can file 11s, but they can't file a 13. Another big difference between these chapters of bankruptcy is the length. Chapter 7 bankruptcy is going to last about 100 to 120 days, 3 to 4 months. That's it. You get in, you get out, you're done. A Chapter 13 bankruptcy, that's going to take usually 5 years, occasionally 3 years, but most of the time you're making 60 months of payments in your Chapter 13. The Chapter 11 is going to vary. It's probably going to be about a year long. Maybe it's longer. Maybe it's shorter, but that one's going to vary a lot more because, again, there's so much more flexibility with what you do in a Chapter 11 and a lot more custom design by the creditors on how your case is going to go. When you file a Chapter 11 or a Chapter 13, you are proposing to the court a plan on how you're going to deal with your debts. You're going to make payments. You're going to sell this or sell that. And then the creditors can review it. The trustee, if there is one, gets to review it. The judge gets to review it. And when that plan is confirmed and approved, then you're going to have a successful bankruptcy as long as you follow the terms of that plan, which usually involves making payments. Chapter 7 is the one that's different here. In Chapter 7, you don't file it with a plan. That doesn't mean you don't have any idea what you're doing. But in Chapter 7, the plan is just you let the trustee decide if there's any non-exempt property that's worth selling. A second house, mineral rights, a third car, a fancy sports car, extra ATVs, extra tractors, extra things that you don't actually need for your fresh start. That's what gets sold in a Chapter 7. And that's where it's different than the 13. Let's say that you have a Corvette that you want to keep. It's not necessary for your bankruptcy. In Chapter 7, that fully paid off Corvette would probably be sold to pay your debts to the creditors. But in Chapter 13, you can keep it as long as you pay extra money to the creditors. So that's one of those huge differences between a 7 and a 13. The 7, you get out of debt, but you might lose your Corvette. The Chapter 7 and the Chapter 13, the filing fees are about the same, $300-ish. The Chapter 11, you have to pay fees multiple times in the case, so you could be paying thousands of dollars just in court costs. But then let's talk about attorney fees. Chapter 7, your attorney fee is going to kind of be set by the marketplace. How much work is involved? How good of an attorney are you going to hire? That's going to dictate what your Chapter 7 costs. It's not really set by the court most of the time. On the other hand, a Chapter 13 is going to be completely controlled by court rules. And what the court rules usually say is something like this. The attorney is encouraged to accept a reasonable retainer before the case is filed. Maybe half the money. In my office, we usually ask for about $2,000 down. That covers about $500 in costs, postage, court counseling, credit costs. Those things are all covered in that $500, and then about $1,500 of initial attorney work. Then in the 13, additional payments to the attorney are all governed by court order and are all paid through the bankruptcy trustee. So it's a highly structured, highly controlled process set by court rule. And all the attorneys are going to charge pretty much the same money here in Chapter 13 because it's set by court rule. So in Chapter 13, there's no reason not to choose the best possible attorney because they're all probably going to cost the same amount, regardless of skill, expertise, years of service. Now in Chapter 11, this is one of those areas where your attorney fee bill is just going to get tremendously expensive. These are the cases that start at $35,000, $50,000, $75,000 and go up from there. These are the cases where some attorneys are charging $1,600 an hour, $2,000 an hour or more. And these cases can get tremendously expensive. So if you want one of those custom bankruptcies, that Chapter 11 design your own bankruptcy system concept, you can have it. You're just going to pay a lot in attorney fees. So at the broadest level, those are our different chapters, 7, 11, and 13 that we use for individuals. But most of the time, you're going to be looking at a Chapter 7 where you don't make any payments, but maybe you lose something that's not protected as part of your fresh start, or Chapter 13 where you're making 5 years worth of payments, but you're not losing property unless you voluntarily want to sell it. And then Chapter 11, the customized, expensive type, that can be yours too, but you'll probably need to hire a downtown, high-priced tower law firm to do it.